Hello friends. A popularly known YouTube news channel, that is the 4 p.m. news channel, was recently blocked by the Indian government. This blockage was done by the Indian government without giving a prior notice to the YouTube news channel operators that on what basis or on what grounds the blockage was done. But as soon as the blockage was done, within 24 hours, a receipt from the YouTube was received that the blockage was done on the grounds of maintenance of public order and for the national security. The exercise of this blockage by the Indian government was done as per the information technology blockage rules. The information technology blockage rules prescribes that a prior notification or a prior notice as to the reason stating the grounds for which the blockage has to be done has to be sent to the news channel operators, or in this present case, that as per these grounds your channel is being blocked. But this notice or notification is not sent or is remained undisclosed by the Indian government, and the blockage was done. Concerned by this, the news editor-in-chief Sanjay Sharma has approached the Supreme Court stating the removal of this ban imposed by the Indian government on their news channel, as it is violative of Article 19(1)(a), that is freedom of speech and expression, and the power exercised by the government is ultra vires of the constitution, and it is arbitrary in nature. Article 19(1)(a), that is freedom of speech and expression, is one of the most important aspects of the fundamental right, which cannot be curtailed by any government of democracy. The freedom of speech and expression is blood or a lifeblood to the democracy, wherein each and every individual gets a right to participate in the political and social activity of the government and to review the political stances taken by the ruling government bodies. So if this Article 19(1)(a) is curtailed, the freedom of speech, when it is taken away, it's not a pure democracy. The freedom of press comes within this ambit of freedom of speech. Freedom of speech does not only mean the verbal speech, but also includes the depiction of thoughts or the depiction of ideas to the public. The freedom of speech and expression is not only enshrined in the Indian Constitution, but is also an international mandate under the Universal Declaration of Human Rights and the International Covenant on the Civil and Political Rights. As per the freedom of speech and expression mentioned under the Article 19(1)(a), being a fundamental and integral part of fundamental rights, it can be only reasonably restricted by the Indian government, and those reasonable restrictions have to be under the following grounds enshrined under the Indian Constitution, and these grounds are for the security of the state, sovereignty and integrity of the country, and for the maintenance of friendly relation with the foreign country, for the maintenance of public order, defamation, hate speech, or for the maintenance of decency or morality. And none of the any of the conditions exceeding these reasonable restrictions can be exercised by the government to suppress the freedom of speech and expression, because it is stated that there should be a least intervention by the government when it comes to the freedom of speech and expression, because it is the essence of the democracy. There are many judgments which support this argument. For example, in case of Romesh Thapar vs State of Madras, wherein it was stated that the freedom of speech and expression includes the freedom of propagation of ideas and circulation of these ideas. So when one possesses any idea and propagates it, and the circulation which is done with regard to the propagated idea is under the ambit of Article 19(1)(a), and it cannot be restricted by the Indian government because it forms an essential part of Article 19(1)(a). In another leading landmark judgment of Kedarnath vs State of Bihar, it was held that any criticism, however strongly it is with regard to the public policy, it does not amount to sedition unless and until it is leading for the incitement of offense or leading to the breach of public peace. The Information Technology Act 2000 has empowered the Indian government under the Section 87(2) Clause Z, wherein it states that the Indian government can formulate any rules and regulations to regulate any of the provisions mentioned under the Information Technology Act for the blockage of the public access from any particular information which the government seeks to block. And there are adequately mentioned grounds under the Section 69A of Information Technology Act. This states that if the following grounds are satisfied, only on those grounds can a designated officer who is in charge for the blocking can exercise the power to block as per the directions mentioned under the Information Technology Blockage Act. So these grounds mentioned under the Article 69A is for the security of the state, for the protection of the sovereignty of the state, for the protection of international peace or international friendly relationship with the foreign state, or for the sake of protection of public order, or for prevention of incitement of offense for the public, which is prohibited by the criminal law in India. So under any of these grounds mentioned, if the designated officer is satisfied and a reply or on the meeting of that concerned person who has generated such information from the computer sources comes to a conclusion that the grounds mentioned under the Article 69A, 69(1)(a) is satisfied, and based on this particular ground the blockage is necessary, only on that circumstances can the blockage of such particular information be done. And prior to this blockage being done, it is a mandatory requirement for the designated officer to send a written notice to the concerned person who has generated such information that on basis of the following grounds, or on the basis of one of such following grounds mentioned under 69A clause 1, that the information generated by such concerned person is necessary to be blocked, and there should be a reply from such concerned person within 24 hours, or that such concerned person should meet the committee prescribed under the Information Technology Blockage rules to be met at such place and time within the 48 hours. If this is not done, only then can the designated officer exercise its power discretionarily to, if satisfied that one of the following grounds mentioned under the Section 69 clause A, that the blockage is necessary, can proceed with the blockage. But in the present case, the blockage which was done, there was never taken a reasonable step to intimate the news channel operators with regard to the blockage being done, or on what grounds the blockage is done. So this is a significant impact to the Indian democracy, which I say because this not mentioning with the prior notice of blockage is nothing but a pure act of arbitrariness by Indian government. And on the other hand, the designated officer has never waited for a reply by the concerned person who has generated such information, in this particular case the 4 p.m. news channel, that they have to come and meet the committee. This step, which is an adequate due process of the blockage which has to be followed by the Information Technology Blockage rules, has completely been rejected, have completely been not complied with. This act of blockage by the Indian government is nothing but a clear violation of Article 19(1)(a) and is ultra vires of Indian Constitution. Now, our opinion with regard to the same is the exercise of power by the designated officer of the Indian government with regard to the blockage being done. There is already an existence of threat by the blockage rules of the Information Technology Act that if the blockage is not done, they would be subjected to imprisonment for a particular term, or fines would be imposed. And additionally, the concerned party who has generated such information is not informed by the designated officer in the present case. So this circumstances is clearly in non-compliance with Rule 7, 8 and 9 of Information Technology Blockage Rules. And this blockage rules specify that only a particular information can be blocked, or a particular information which is in derogatory with the grounds mentioned in section 69A clause 1 can only be blocked, and not the entire channel. But in the present case, the entire channel is blocked and not the particular content or the specific information. And the information or the content being blocked has to be satisfied under the section 69A clause 1. But in the present case, the blockage was done first, and after the blockage was done, then after the news channel was blocked, then the YouTube, that is the intermediary herein in the present case, has intimated YouTube news channel operators that the blockage was done on the basis of security of the state and for the maintenance of public order. But it was not priorly intimated before the blockage was done that there has to be on the basis of this following ground that the blockage is necessary. Additionally, on the other hand, the power exercised by the designated officer with regard to the blockage of the entire 4 p.m. news channel is an unconstitutional act, because the Blockage Act on itself provides for blockage of only that specific content if it is under the grounds mentioned within that 69A. Can the blockage be done, that too with the prior notice? But that information is not blocked here, but the entire news channel is blocked, which is in derogation with the law and the due process. The process of blockage done by the designated officer without a prior notice and the broad discretionary power to block the whole news channel was not only in accordance with the law, but also the due process has been completely ignored. This has led to the uncertainty or unpredictability of the powers exercised by the designated officer, because it has led to the failure of democracy and violation of Article 19(1)(a), which is an inherent right of an every individual. The discretionary power exercised without following the due process is apparent in this present case, wherein the designated officer has proceeded with the blockage without giving a prior intimation or notice, and the principles of natural justice are clearly disregarded here. There should be an opportunity for an opposite concerned party to be heard before the blockage is done, or there should be a procedure established, or there should be an authoritative control to check into the actions done by the officer concerned with regard to the blockage. And our opinion with regard to the same is there should be an establishment of a tribunal or a specialized court which take into account the actions of this concerned officer or the designated officer who proceeds with the action of blocking, and checks into the fact that the principle of natural justice, that is the opposite concerned party, is heard before the blockage is done. And if these due process are not followed, it is a gross violation to Article 19(1)(a), that is freedom of speech and expression, and it is a failure of the democracy. There should be a check and balance system of the procedures followed by the designated officer with regard to the blockage, and also the review committee herein specified in the blockage rules should be substituted with a tribunal or a specific court which takes in the specialized matter, so that there is an always check with regard to the protection of democracy and constitutionality with regard to the freedom of speech and expression. The fundamental rights are important aspects of democracy. Without fundamental right, a state is an authoritative or a dictatorial state. A fundamental right is a constitutional gift to every individual in India, and let us all be aware of fundamental rights which we possess, and let us not be ignorant to leave the fundamental rights at vain. Let us all stand always together to protect the democracy. Thank you.